It's on.
Ladies and gentlemen, the burden of the people is to establish all the elements of the crimes charged beyond a reasonable doubt, no more and no less. I am also required, members of the jury, to charge you with respect to the elements of the punishment. As I told you previously, the question of the possible punishment of the defendant should be convicted on any crime is of no concern to you. It should not enter in any sense into your deliberations or influence them in any way. If there should be a finding of guilt as to the defendant on any count, the duty of imposing sentence rests exclusively with the court. It is of no concern of yours, members of the jury. Now, members of the jury, I am going to consciously and intentionally refrain from reviewing the evidence in this case, lest by some inadvertent emphasis or unintentional omission I appear even remotely to suggest to you the course you should follow. I say to you and point out to you that this case has been a rather brief one, inasmuch as it was a full day of testimony. I am heartened in not reviewing the testimony because as I watched this jury, and I have confidence that you paid attention, and I am sure that you have all followed the evidence conscientiously and attentively, and I know that all that is for your determination, and it is fresh and is present in your minds. Now, members of the jury, further as to the testimony, please remember, and I mentioned this to you before, and I do not wish to belabor the point, it is your recollection that controls, not counsel's, as they recounted their recollection of the evidence in their summations, nor indeed mine, as I may refer to the testimony in my charge as it continues. It is your recollection, and your recollection alone, that controls. Let me make one thing clear to you, too, with regard to the testimony and of the witnesses, and that is the distinction between the testimony actually given at this trial and the testimony made prior to the trial at some other time. You will recall the defendant's counsel examined one of the witnesses, Kenneth Drake, through the use of some testimony given at a prior proceeding. Now, such prior testimony not made before you on an earlier occasion is not legal equivalent of evidence. You hear from the witness who testifies here. Such prior testimony is not affirmative evidence of guilt or innocence, or even of the facts in that prior testimony. It is what is called in the law hearsay. It is admitted solely to assist you in weighing the credibility of the witness as to what he testified to before you. In other words, how much weight shall I give to this witness to what he said here, bearing in mind that he either said something different on an earlier occasion or perhaps the same thing as the case may be. I also advised you, which you have already been told, I'm sure you know by now, that if during the deliberations, if you desire any of the witness's testimony read back, please notify a court officer, and you will then be brought back into the courtroom and the reporter will read it to you. You may, if you so desire, take in with you all of the exhibits that have been received in evidence and have them with you during your deliberations. I further charge you, members of the jury, that whenever you can consistently reconcile conflicting testimony, it is your duty to do so, because human experience has taught all of us that persons present at the same time, at the same events, do not and cannot possibly describe it in exactly the same way. But where you find any conflict in the testimony that you cannot reconcile, do not hesitate to cast aside that which you believe to be exaggerated or incorrect or willfully perverted and accept that which you believe to be correct and to be truthful. Now let me direct your attention to the crimes that were charged in the indictment. I read this indictment to you at the beginning. Let me read it to you briefly now once more. Jurors, in this case, really, the major issue, perhaps the sole issue, is, did the defendant, or did he not, shoot and kill the deceased, in this case, one Crane? There is not, as I see it, any controversy with regard to the fact that the deceased Crane was shot and killed on the particular day in question at a particular locale. The only issue is the one I set forth to you. Now, you must use your common sense. How do you really weight credibility of a witness? I don't know of any specific method that can be used which is better than the one you utilize every day in your very lives. For every day, every week, Since you were able to reason and think, you judge credibility of people. You may not understand it as such, but that is the fact. For in the very places where you are employed, and the very businesses that you may own,
Too fast.
too fast.
Yeah.
$8.70.